The final preparation phase for a trial includes several well-defined steps. They include reviewing your notes, preparing mentally, rereading and refreshing your memory of key documents, reports, and depositions, and reviewing the other experts' work and preparing your attorney with a series of valuable questions that he can ask the opposing expert. Beyond those steps, you can help by explaining the purpose of any of your questions that may not be self-evident to the attorney. Still further, you can offer suggestions for follow-up questions that your attorney can consider using depending on the answers the other expert gives him to the initial set of questions. It's absolutely essential that you review your own materials. You should always start by rereading your expert report. Typically, your report includes your major opinions and conclusions. All attorneys involved in the case will question you about its contents. In addition, the expert report includes a list of all the materials you reviewed and the information you relied on for your conclusions. It includes the details that formed the basis for each opinion expressed. An important tactic for you to consider is that reading your own expert report is an excellent way to refresh your memory about what you concluded and why you came to those conclusions, however long ago all that was. Next, you should open the rest of your file, which typically you should organize chronologically, and read everything in it right down to your own little scribbled notes. You should study those notes about meetings, conversations, tests, results, and any discoveries. If your case file contains other documents that you considered important at the time, you should either reread them completely or lightly review the information in them. Generally, by the time you reach a trial, many depositions have taken place. Your expert report always refers to depositions that you reviewed. Within the expert report, though, you will refer to other depositions and statements within them that you probably used to form your opinions. You should reread those deposition sections to refresh your memory about who said what, how they said it, and in what context they said it. If you fly around the country or abroad to work on cases, it will not always be practical to revisit locales and relevant sites. If your case is local, however, that may be easy for you to do, going back to those sites. Refreshing your memory visually about the location of events can be very helpful. If not, however, do your best with any photographs that you have taken, recordings you may have made, or any notes you may have made about the site or the people at the site. In general, you should create your own chart or listing of the key people involved in the case. You will answer questions involving people in the case, and you will have to know each of the key participants' names. The jurors, judge, and the attorneys will expect you to be familiar with much of what they said, as well as their roles in the case and the opinions you are expressing about them. Overall, you should be familiar and comfortable with whatever you have committed to paper and included in your case file. Further, you should have at the tip of your tongue the facts and findings that have been discovered in the case by you or anyone else whose materials you relied on for your final opinions. By this point, you should be able to speak your opinions, to present your methods and your findings, and to answer questions about them without any undue hesitation. There are other relevant case documents that you obviously will need to review as well. In your case report, you explicitly listed everything that you reviewed and considered that led to your opinions. Your case file or folder may not physically include entire deposition transcripts and case exhibits that have been Bates stamped, although you may have your copies on a desk or in a box. However, these are equally important to review in preparation for trial as well. Answering questions during trial can improve greatly based on how carefully you have reread relevant case documents that may not necessarily be a physical part of your smaller case file folder. Depending on the discipline in which you pursue being an expert witness, you will base your opinions partly on your own professional research, investigations, and tests. But more than that, you may also base your final conclusions on industry standard information, such as formal and accepted conventions and codes. If you base your opinion on any official documents, standards, or published industry practices, then you should also review those documents and refer to them during your testimony. For example, most jurisdictions have local civil codes that govern the drilling of a well or the paving of a road. Companies engaged in interstate commerce may be subject to federal rules and guidelines that have specific codes governing them. Doctors, psychotherapists, and insurance companies are subject to codes or identifiers that are accepted in their industries and that provide a framework for identifying and treating mental illnesses. The manual that they use is called the DSM. If you are testifying in a medical case, it would be wise for you to review the relevant pages and the codes within that manual to refresh your familiarity with the ones at issue in your case. By the way, you should always know the meaning of key acronyms in your industry. Other people do not necessarily know the acronyms that you use, but you should refresh your memory about the meaning of common terms and acronyms. It will not sound very good if you cannot explain a key industry acronym in English. What would you think of a testifying psychiatrist who did not know that the DSM, touted as the Bible of the psychotherapeutic industry, stands for Diagnostic and Statistical Manual of Mental Disorders?